Hello, hi guys. This is CA Balakrishna from lecturepedia.in. How are you? Hope you people are doing well. Even I am fantastic. By previous class, we have completed all the chapters related to directors, right? Now we will be starting with the fourth chapter, that is inspection, inquiry, and investigation. Basically, if you see in this chapter, you will be having sections from 206 to 229, around 23 sections you will be having in this chapter. You'll find the number of sections more, but the content that will be there in those sections is very much small. Okay, basically this chapter, it is a very small chapter. You can expect some 3 to 4 marks, okay, from this chapter, or sometimes 1 or 2 marks. Now, first of all, let us understand name of the chapter. It is having 3 terms. One is inspection, inquiry, investigation. What is the difference between these 3 terms? First of all, starting with inspection. Inspection means general scrutiny of books of accounts. Okay, general scrutiny of books of accounts or general scrutiny of any documents is known as inspection. Okay, in the inspection, what you'll do, you'll just inspect the records, inspect the documents. Okay, that is known as inspection. See, general scrutiny to find whether there is any fraud. Okay, whether there is any fraud, whether there is any misstatement, whether there is any misrepresentation. Okay, so inspection is general scrutiny of documents or records or financials. Now, investigation. Investigation involves deep understanding and deep review of an area to find out who has committed fraud, or to find out whether there is any fraud in that area. See, basically in most of the cases, in 99% of the cases, investigation will start once the fraud has been committed. Okay, once the fraud has been identified, investigation will start to determine who has committed that fraud, how much amount is involved in that fraud, from how much time that fraud is being conducted. Okay, to identify these items, investigation will be done. So in most of the cases, investigation will be done after the fraud has been identified. See, fraud has taken place, now you are investigating to find how fraud has taken place. Okay, so that is difference between inspection and investigation. Coming to the final term, inquiry. Inquiry means asking questions. Okay, you'll ask questions and you'll expect some answers for those questions, that is known as inquiry. Okay, you'll inquire with the people by asking some questions and you'll expect some answers, right? So that is known as inquiry. So the name of the chapter is inspection, inquiry, investigation. Now here registrar of companies is there now. Okay, we'll discuss that later on. Basically this is the understanding of this chapter. Now, in which situation inspection will be conducted, in which situation investigation will be conducted. Okay, we'll discuss that starting with section number 206. First of all, we'll start with inspection. Okay, inspection means general scrutiny of records or documents. Now you all know that uh, for every financial year, companies will file their financial statements, annual return, with ROC, right? You'll be filing MGT 7 and AOC 4. These are annual documents that you will file with registrar. Now, once, not only these 2 documents, you will file various other documents, various other forms with the ROC through MCA website. You'll be filing, right? So once you furnish this information to ROC, see, company files that information to ROC. After seeing those information, if ROC wants any additional information or explanation, it will ask for further information and explanation. And companies past and present employees has a duty to furnish such information that the ROC has asked. Okay, I hope you are understanding the flow. First of all, company will furnish the information. ROC will see the information, and if it requires any other information or explanation, it will ask the company to provide such other information or explanation. Now, once ROC asks the information, it becomes a duty of present employees of the company to give the information, and if the information related to previous years, then the employees who are employed by the company in those previous years, that means the past employees will also be having responsibility to give information to ROC. Okay, now once all such information, further information and explanation has been given to the ROC, what ROC will do is ROC will inspect. See, now basically ROC has asked for the information, and once the ROC has asked for the information, the company, if no information is furnished by the company, okay, if company doesn't furnish any information or inadequate information is furnished by the company, okay, ROC has asked further information or explanation, but company has given only half of the information which has been asked by the ROC. In that situation, or on scrutiny, register satisfied, FIRs are unsatisfactory. Okay, on scrutiny of the information furnished by the company, now ROC asked for the information and the company has given that additional information also. Once all such additional information explanation has been given, ROC will scrutinize that, right? In that scrutiny, if the ROC finds that, see, ROC means register of companies, if ROC finds that the information is unsatisfactory, then what ROC will do? Okay, in these three situations, ROC is having power by notice call for inspection. Okay, ROC has asked for further information or explanation to the company. Company has not given such information, first case, or company has given such information but only some of the information is given, second case. Coming to the third case, company has given complete information that the ROC has asked, but after scrutinizing that information, ROC finds that there are some lapses in the information. Okay, there is some misstatements in the information. Okay, the information is unsatisfactory. If ROC feels so, then by a notice, ROC can call for inspection on the company. Okay, so this is the scenario where inspection will arise. Okay, once inspection notice is issued to the company, ROC will appoint an inspector. Okay, inspector will be appointed to inspect the books of accounts, records, documents of the company. Okay, inspect means going through the books of accounts, reviewing, scrutinizing the books of accounts and records to find out whether there are any frauds. Okay, that is known as inspection. Investigation means after the fraud has been found out, to identify how much amount is involved, who has committed the fraud, okay, from how much time this fraud has been being committed, that is known as investigation. Okay, so inspection will be conducted to find out whether there is any fraud or misrepresentations. Okay, so this is the triggering point for inspection under section 206. Okay, central government also has power to call for inspection. Okay, not only ROC, if central government wants, even it can also give a notice of inspection to the company. Next, coming to the inquiry, who is having power to conduct inquiry? See, power to conduct inquiry, first of all, registrar, based on the information furnished by the company. Okay, company will furnish various information now here. Based on that information, if the ROC wants, it can conduct an inquiry on the company. Okay, inquiry means asking questions to the company. Okay, see, once the ROC has received the information, it can either conduct inquiry or it can either call for inspection. Okay, inquiry means just asking the questions. Inspection means reviewing, scrutinizing the books of accounts completely. Okay, so registrar is having power to call for inquiry based on the information that the company furnishes, or represent reported by any person that company is carrying business fraudulently or unlawful purposes. Okay, if any third person gives a complaint to the ROC or reports to the ROC that company is doing frauds, the company is doing its business fraudulently. In such a situation also, ROC can conduct an inquiry on the company. Next, grievances of investors are not addressed. Okay, if the grievances of the investors, that is the complaints, the queries of the investors are not addressed by the company, then also ROC can conduct an inquiry, can ask the company why you are not responding to the grievances of the stakeholders. So in such situation also inquiry can be conducted by registrar or ROC, both are one and same. Next, central government. Okay, by central government direction, registrar or inspector can conduct inquiry. Okay, central government is also having power to conduct inquiry, but central government will exercise its power through registrar or through inspector. Okay, so this is section number 206, power to conduct inspection and inquiry. Okay, this power to conduct inspection and inquiry are available with registrar of companies or central government. Okay, registrar of companies, based on the information furnished by the company, it can call for inspection or inquiry, and central government also, if it wants, it can call for inquiry or inspection on the company. Hope that is clear. So this is section number 206. Next, moving to section number 207, which is inspection. Okay, conduct of inspection and inquiry. That is how this inspection and inquiry will be conducted. Now, ROC has given notice to the company that we will inspect your books of accounts. Now, will ROC itself will come and inspect? No, it will appoint inspector. Okay, that procedure we'll see. Now, duty of officer, basically that inspector, what is the duty of that inspector who has been appointed to conduct the uh, inspection or inquiry. So, sorry, not the officer. Here, officer refers to officer of the company. Okay, here officer refers to employee of company. Now, registrar has ordered for inspection on the company. Once registrar has ordered for inspection, what will be the duty of employees of that company, or the what will be the duty of officers of that company? Let's see. The officer of the company shall produce all documents, statements, information, explanation to the registrar. Okay, he must furnish all the information, explanation, and statements to the registrar. Whatever the information has been asked by the registrar, that has to be furnished. Next, render assistance to the registrar. Whatever assistance is required to the registrar, that has to be given by the officer to that registrar. Okay, whatever guidance or whatever help is required to the registrar in that inspection, it has to be provided by the officer. Officer means officer of the company, employee of the company. Next, powers of inspector or registrar. Okay, what will be the powers of that inspector who has been appointed to conduct inspection? He can take photocopies, that means Xerox copies of the records, documents, and books of accounts of the company. He can place identification marks on the books of accounts, records, documents of the company, and he is also having all powers of the civil court. Okay, whatever the powers that the civil court is having, all those powers this inspector is also having. Okay, so this is conduct of inspection and inquiry. Basically, you can call this section as powers of inspector and duties of officer of the company during the inspection and inquiry. Right? Yes. Next, section number 208. Now, ROC has given notice of inspection and appointed inspector to conduct inspection. Now, inspector, after conducting the inspection, he will give report of inspection, right? That is section number 208, report of inspection or inquiry. Okay, even if the registrar has given notice of inquiry, then also registrar the inspector will be appointed to conduct the inquiry. Now for inquiry also, report of inquiry will be prepared by the inspector. Now the registrar or the inspector, they will prepare the report of inquiry or inspection, so that will be forwarded to the central government. Okay, this report will be forwarded to the central government and can recommend for further investigation. See, now this is report of inspection by registrar. In this report, registrar can recommend for investigation on this company to the central government. That means this is a starting point for investigation. Okay, the report of inspector can be starting point for investigation, can be triggering point for investigation on the company. Okay, this is one of the triggering point for investigation on the company. Okay, the report of inspector or the report of inspection can be triggering point of investigation on the company. Okay, in this report of inspection, the inspector can recommend to conduct investigation on the company. Hope that is clear. So that is section number 208. Next, moving to section number 209, which is search and seizure. Basically, what will be seized? Books of accounts, papers, documents. Okay, these will be seized. When these will be seized? Basically, registrar has received a complaint that company is conducting its business fraudulently, or it has manipulated its books of accounts. Okay, somehow registrar came to know that companies books of accounts are fraudulent, or some frauds are being committed by the company. Now by the time registrar issues notice of inspection or notice of inquiry on the company, there is a possibility that company can alter these books of accounts or documents. To avoid such a possibility, what registrar will do is, see, books, papers of key managerial personnel, any director or auditor or company secretary likely to be destroyed, falsified or mutilated. Okay, if registrar of company feels that books of accounts that are available with the KMP or any director or auditor or company secretary are likely to be destroyed or falsified, okay, altered or mutilated means also altered. Okay, in if registrar of company feels so, then registrar or inspector, after order of special court, can search and seize those books of accounts that are available with these people or with the company. Okay, so that is search and seizure. Now after the registrar has seized those books of accounts, it has to again give them back to the company within 180 days. Okay, after the purpose is fulfilled, after the inquiry or the inspection has been completed, within 180 days. Okay, within 180 days from the date of seizure, the books has to be returned. The time limit is 180 days. However, after returning, if the registrar of company again wanted those books, it can again take those books after 180 days. See, return books in a period not later than 180 days. However, if required, further can call by order in writing. Okay, after returning, if the registrar again wants those books, then it can again by writing can call for those books. Hope that is clear. So that is section number 209. So till now we have seen inspection inquiry. Okay, on whom inspection inquiry will be conducted? On company. By whom? Registrar of company or central government. Who will be appointed to conduct inspection? Inspector will be conducted. Now inspector will be appointed. After inspector conducts inspection, he will give report of inspection. In that report of inspection, he can recommend for investigation, right? Yeah. Now coming to the investigation. Now investigation, it can be of 4 types as per this chapter. Okay, we will be discussing about this investigation in 4 sections, 4 types of investigations. First of all, investigation into affairs of the company. Okay, affairs means business activities or day-to-day activities of the company. So section 210 deals with investigation into affairs of the company. Section 216 deals with investigation into ownership of the company. Okay, in section 216 you will identify the real owner of the company. We'll see that. Okay, that is investigation into ownership of the company. Next, section 212 investigation by SFIO. SFIO means serious fraud investigation office. This section 212 will be discussing at last. Okay, this is somewhat serious investigation. Okay, if the investigation has been handed over to SFIO, it means that the investigation is serious. Okay, some huge amount is involved in the fraud, and large parties are involved in the fraud. Okay, only in such situations SFIO will enter into the scene. Okay, SFIO means serious fraud investigation office. Next, section 213 deals with investigation in other cases. So these are the four sections with respect to the investigation that we will be discussing. Now just a second. Hello, hi guys. If you're watching this class till this point of time, I guess you thoroughly liked this class. Now I'm having an exciting news for you people. We're also having CFNL audit classes available with us. And in these audit classes, we have discussed all the concepts with the help of lively PowerPoint presentations. I'll just show you those PowerPoint presentations. If you see, this is a PPT for digital audit and assurance. You can find the lively images for each concept. Okay, based on the concept I have given images for the in the PowerPoint presentation, and these same images you will also find in our color book that you will be getting. If you see, this is the PowerPoint presentation for SA 299. Okay, based on the concept I have designed the PowerPoint presentations. Just by seeing that image you can easily remember the concept. So with the help of these PPTs we will be discussing in our classes. And this is the PPT for SDG and ESG. You can see how lively the PPTs are. I'll also show you the books that you will be receiving. If you see the same images that you have seen in the PowerPoint presentation, you can find here in our book. So the same image you will find, and these books, they are completely color books, and you can also find the important terms, the key terms highlighted in red. Okay, in the entire big book you will find the key terms highlighted in red. And also if any concept is important, here I have given important marking. So this is the concept book that you will be receiving, which is completely a color book. You can see. Okay, so like this, the concept book you will receive, and also question bank you will receive. Even the question bank is also a color book. So mostly you will not find question bank in color anywhere, but we are giving even the question bank in the color. Okay, so these books and these books you will receive along with the classes. So if you want to purchase the CA final audit classes, you can visit our website lecturepedia.in and you can place your order. Now you can continue watching your class. So starting with section number 210, investigation into affairs of the company. Now who can order for investigation into affairs of the company? Central government can order into investigation into affairs of the company. See, remember, only central government is having power to order for investigation. Okay, apart from central government, no one can order for investigation into company. Okay, so investigation has to be ordered only by central government. Now central government, what will be the triggering point for the central government to order for investigation? First of all, based on the report under section 208, if you see in our in section number 208, the inspector has given his report of inspection to the central government. Now in that report, the inspector can recommend for investigation. So if the inspector has recommended for the investigation, then central government can, based on that report, order for investigation. So that is one of the triggering point for investigation. Or special resolution by the company. Now company, in the company, shareholders are feeling that the board of directors, they are doing some fraud. Okay, shareholders are not aware or not able to identify what fraud the directors are doing, but there is some fraudulent activity that is happening in the company. So shareholders wanted to conduct investigation on the company. In such case, shareholders, by passing general meeting special resolution, can decide to apply to the central government asking for investigation. Okay, see, now shareholders are there na, shareholders, by passing general meeting special resolution, they will ask central government to conduct investigation on the company. Okay, so to request for investigation, first of all, the shareholders has to pass special resolution. Okay, that means more than 70% of the shareholders has to approve for investigation. Okay, special resolution means 70%, right? Then also central government will start investigation. So this is also one of the triggering point. Okay, general meeting, special resolution by shareholders. Next, in public interest. Okay, on a suo motu basis, central government itself can order for investigation into the company in the public interest. Okay, these are the three scenarios in which investigation can be conducted. Or based on order of court or tribunal, central government will order for investigation. Okay, if let's say any court or tribunal has given an order to the central government stating that you conduct investigation into affairs of this company, in that situation also central government will conduct investigation. Now here also investigation, central government, it will not directly conduct, it will appoint the inspector. See, note, central government will appoint the inspector to conduct the investigation. Hope that is clear. Now in this second situation is there na, investigation requested by the shareholders. Now in that second situation, to bear expenses of the investigation, shareholders have to deposit certain amount with the central government. That amount, it will be determined based on the turnover of the company. See, security amount for expenses of the investigation. If the turnover of company is up to 50 crore, then 10,000 has to be deposited by the shareholders with the central government. Then central government will start the investigation. If the turnover is more than 50 crore but up to 200 crore, then 15,000 rupees security amount. If the turnover is more than 200 crores, then 25,000 is the security deposit. However, this security deposit is it will be refunded to the shareholders if prosecution has been proved. Okay, if central government in the investigation finds out that really some person is conducting fraud, or really the company is conducting fraud, in such a situation, central government will refund this security deposit to the shareholders. If no fraud has been found, if everything was fine, then that means if prosecution has not been resulted as a consequence of investigation, in such situation this deposit amount will not be refunded. See, note, this will be refunded if investigation results into prosecution. Okay, prosecution means once the criminal has been identified, you will prosecute him, right? So if the investigation results into such a prosecution, that means if investigation finds out some criminal, then the security deposit amount will be given back. That is investigation into affairs of the company, section number 210. So who is having power to conduct investigation into affairs of the company? Central government is having power. How central government? What is the triggering point for the central government to order for the investigation? Based on the inspector's report under section 208, or based on general meeting special resolution of the shareholders, or suo motu in the public interest, or based on order of court or tribunal. Okay, in case of shareholders request for the investigation, then certain security deposit amount will be taken. However, such security deposit amount will be refunded to the shareholders if prosecution has been done because of that investigation. Okay, next, section number 213, investigation into affairs of the company, other cases. What are these other cases? Okay, all cases where members ineligible to file oppression complaint under section 241. Now under oppression and mismanagement, shareholders, they are having power to file application to the tribunal under section 241 against the management, that uh, the activities of the company are in such a way that they are oppressive to the shareholders. Now, in order to file such oppression complaint, there is certain minimum requirement of shareholders, and also tribunal should satisfy that uh, tribunal should prima facie satisfy that certain oppression is being involved in the company. Only then tribunal will accept the application of the shareholders, and also there are certain 4 or 5 conditions to accept the oppression application under section 241 by tribunal. Now, if those conditions are not satisfied to file oppression application to the tribunal, then shareholders can utilize this section number 213 to conduct investigation into affairs of the company. Okay, so here there is a link between section number 213 and section number 241. I guess we have not yet discussed operation and mismanagement, but if you have already have an idea of operation and mismanagement, you can understand this, or else in the coming classes we will be discussing operation and mismanagement, then you will understand this point. Okay, now, so application to the tribunal can be made by those shareholders, okay, who are not able to utilize section number 241. Here also, to make application to the tribunal for investigation, certain basic requirement is there. See, if the company is having share capital, then not less than 100 members or members holding up to 1/10 of the voting power has to make the application in order to accept the application. In case of company not having share capital, then not less than 1/5 of the total members have to make the application in order to accept the application. Now you might get a doubt, sir, here also there are certain limits na, just like section 241, here also certain limits. Now shareholder has come to section 213 because he is not able to file operation application under section 241 because of not satisfying those conditions. If he has come to section 213, here also you have kept certain limitations, like minimum 100 members has to make the application. In case of having share capital or not having share capital, minimum 1/5 has to make the application. So here also there is some limitation. No, here there is third point also. If these criteria is not met, then shareholder can file application to the tribunal under this. If you see here, application by any other person, okay, under any other person category, shareholder can file application, the application to the tribunal asking for investigation onto the affairs of the company under section 213. Okay, here tribunal need not satisfy. Okay, once the application has been filed, investigation will be started. Okay, next. So now we are saying application will be filed to the tribunal. In which cases the application will be accepted? Business is conducted with intent to defraud creditors, members, or any other person. Okay, if shareholders file application to the tribunal stating that business is conducted with intent to defraud creditors, members, or any other person, so you please start an investigation onto the affairs of the company. Okay, they are conducting the business in a manner to defraud the creditors. Okay, creditors also can file the application to the tribunal asking for investigation under this clause. Okay, application by any other person. Next, persons connected with the formation or management or guilty of fraud. Okay, shareholders or any other person can file application to the tribunal stating that persons connected with formation, that means promoters or management, that means board of directors, are guilty of fraud, they are doing fraud. In such situation you can file an application for investigation. Next, members are not given all information related to affairs of company. Okay, if company is not giving, the board of directors is not giving information to the members about the affairs of the company, in such a situation also they can file a application of application to the tribunal asking for investigation into affairs of the company under section 213. Okay, now once the tribunal has received application from the shareholders or any other person, can tribunal order for investigation? Answer is no. I have already told you, only central government is having power to order for investigation. Tribunal cannot order for investigation. Okay, so in this situation, once the tribunal receives the application, what the tribunal will do is it will order to conduct investigation for central government. Okay, it will ask the central government to conduct investigation. Now central government, we have seen central government can conduct investigation based on order of court or tribunal. So since it has received order from the tribunal, central government will appoint the inspector. Hope that is clear, for conducting the investigation. Okay, now if guilty is proved, then officers will be punishable for fraud under section 447. In this investigation, if any criminal is found out, any fraudulent person is found out, then the punishment that will be given to that person is as per section number 447. Under section number 447 we will be having penalty and imprisonment for the persons who are involved in the fraud. So as per section 447 the punishment will be given if fraud is proved under investigation. Okay, next, section number 216, which is investigation into ownership of the company. Now investigation into ownership of the company means to find out the real owners of the company. See, sometimes what will happen is company will be incorporated and shares will be in the name of some people, Mr. A, Mr. B, Mr. C. So on paper shares will be in the name of Mr. A, Mr. B, Mr. C. On paper Mr. A, Mr. B, Mr. C are owners of the company, but in reality, to invest into this company, amount has been given to Mr. A, Mr. B and Mr. C by Mr. X. Okay, Mr. X has given amount, that amount they have invested in company. So A, B, C are binamis of Mr. X. So A, B, C will act as per directions of Mr. X. So here on paper owners are Mr. A, Mr. B, Mr. C, but actually the real owner is Mr. X, right? So whatever wrong is being conducted, whatever fraud is being conducted in the company, it is being conducted on the direction of Mr. X given to ABC, right? So here in these type of situations it becomes necessary to find out the real owner. So investigation will be conducted into ownership of the company. So here also that first of all application will be made under section 241, right? Now operation and mismanagement application, basically section 241 application means operation and mismanagement application. Now shareholders, if they feel that they are being oppressed by majority shareholders, okay, in the company, okay, the decision of majority shareholders is overriding the minority shareholders. Minority shareholders are feeling oppressed in the company. In such situation they can file application to the tribunal under section 241. Now once this application is filed under section 241, one of the action that the tribunal can take is investigation into ownership of the company. Okay, this is also one of the scenario where investigation into ownership of the company can be done, okay, to find out who are the actual owners. Okay, minority shareholders have filed application to the tribunal complaining about majority shareholders. Now, before taking any action on the majority shareholders, tribunal can first of all conduct investigation into ownership of the company. Who are the actual owners? Whether these majority owners are the actual owners, or is there any other person on whose direction these majority shareholders are acting, just like in the example that we told. Okay, so to find out the actual owner of the company, investigation into ownership of the company can be conducted by the tribunal. Hope you understood this point. Now, application has been given to the tribunal by shareholders under section 241, which is operation application. Now, order to conduct investigation into ownership of the company. Tribunal will give an order to whom? Again, to central government. See, only central government can conduct the investigation. Only central government is having power to conduct the investigation. So, tribunal will also order central government only to conduct the investigation into affairs of the company. Now, then what central government will do? It will appoint inspector. See, central government shall appoint inspector to find out who are financially interested in success or failure of the company. That means who are the actual people who has invested in the company, who are able to materially influence the policy of the company. Okay, who are able to materially influence the decision making in the company. Okay, to find out such a real persons who has a beneficial interest in the shares of the company. Okay, so to find out these persons, okay, to find out these real owners, the central government will appoint the inspector to conduct investigation into affairs of the ownership of the company. That is section number 216, right? Next, moving to section number 222, imposition of restriction on securities. Now, tribunal can also impose restriction on securities. Now, what can happen is tribunal might have ordered the investigation, and the investigation is going on. During investigation, in order to avoid penalty and in order to avoid punishment, the people who have committed wrong, what they might do is they might sell the shares of the company to other people, right? Or they might sell assets of the company to other people to come out of the company, right? So to avoid this, tribunal can impose a restriction on securities, stating that till the time investigation is completed, securities should not be sold. Okay, all the people, they should not sell their securities like this. See, tribunal based on investigation under section 216 or complaint by any person wants to find certain facts about any securities, then such facts can't be found unless restrictions are imposed. Then it can order for restriction on securities for a period not exceeding 3 years. Okay, this restriction on sale of securities can be imposed for a maximum of 3 years. Okay, not only on the restriction on sale of securities, any type of restriction with respect to that security can be imposed for a maximum period of 3 years. Okay, the restriction cannot be for more than 3 years. Next, section 221, similarly, like restrictions have been imposed on sale of securities, the same type of restriction can be imposed on other assets of the company also. See, section 221 deals with the same, freezing of assets of company on inquiry and investigation on a reference given by central government or based on inquiry, investigation or complaint under section 244. 244 again goes to mismanagement. Complaint by creditor having 1 lakh outstanding rupees. Okay, based on this, tribunal has reason to believe that assets of company will be disposed of and is prejudicial to public interest or company's interest. Okay, based on complaint received by these people, tribunal feels that if it doesn't take proper action, there is a possibility that the company might sell off those assets. If those assets are sold off, then even though fraud has been found out, tribunal cannot do justification for the people who has lost amount in that fraud, because there are no assets available to do justification to the people who have suffered loss. So to avoid this type of situation, what the tribunal can do is it can order for freezing of assets for a period not exceeding 3 years. Here also the maximum period for which the assets can be freezed is 3 years. Okay, next, section number 211, Section number 211, it deals with establishment of SFIO. SFIO means Serious Fraud Investigation Office. Now, who will establish this Serious Fraud Investigation Office? Basically, SFIO is a authority. Okay, authority which will conduct investigations of serious frauds. The name itself will suggest Serious Fraud Investigation Office, right? Now, it will be established by central government. The head of this SFIO authority is director appointed by central government. Okay, central government will appoint a person as a director to head or as a chairperson of this SFIO, and this person is not below the rank of joint secretary to the government of India. Okay, a person who is not below the rank of joint secretary to government of India will be selected by central government and will be appointed as director for the SFIO. Okay, central government also appoints such number of experts as required to SFIO. Okay, so this is creation or establishment of SFIO. Obviously, central government will establish SFIO. Okay, next, section 212. Now, SFIO has been established. SFIO will conduct the investigation. What is the purpose of SFIO? Conducting investigations, right? So, investigation by SFIO. CG will assign cases to SFIO. Okay, who has created SFIO? Central government has created SFIO. The work to the SFIO will also be given by central government only. Okay, of all the investigations that are available, if central government feels that this investigation is a particular investigation is very serious, or a particular investigation is very important, then such type of investigation will be assigned by central government to SFIO. Okay, see, CG will assign cases to SFIO based on report of registrar or inspector under section 208. The same, the triggering point of investigation same. Okay, the triggering point of investigation that is allocated to SFIO is also same. Okay, either based on report of inspector or based on general meeting special resolution or public interest or request from department of central government or state government, the same points. Now, once the SFIO has entered into the case, all other authorities who have been handling the case till now has to drop their procedures. They have to hand over entire process to the SFIO only. Okay, till the time SFIO has taken up the case, if that case was being handling by any other authority, that authority has to drop the case there itself and hand over entire activity with respect to such investigation to SFIO. Okay, all the documents, all the proofs, all the evidences that authority that other authority has gathered has to be handed over to SFIO once the SFIO enters into the scene. Hope that is clear. See, other agencies which are dealing the case shall transfer the case to SFIO. Investigation officer conduct investigation, same powers of inspector under section 217. Basically, section 217 we have not discussed. Section number 217 will conduct various powers of inspector. Okay, there will be certain list of powers of inspector. You can go through that powers of inspector. So the same powers will be available with investigation officer of SFIO also. Next, obviously, officer of company must cooperate to the SFIO during this investigation. Once SFIO has completed the investigation, it will submit its investigation report to whom? To central government, right? Next, officer not below the rank of assistant director of SFIO can also arrest person if authorized by central government. Okay, SFIO is also having power to arrest arrest any person. Okay, if ordered by central government. Okay, however, such power is available with such officer who is not below the rank of assistant director of SFIO. Okay, to arrest a person, the power is available with the officer whose rank is not below the assistant director of SFIO. Okay, now after he has been arrested, okay, after the person has been arrested, you will forward order and relevant documents to SFIO office. Within 24 hours, present him before special court, judicial magistrate or metropolitan magistrate. This is procedural activity. Okay, so this is the investigation by SFIO. Next, section number 215, a small section which states that firm, body, corporate, association cannot be appointed as an inspector. That means inspector must be an individual. Okay, you cannot appoint a firm, body, corporate, or association as an inspector for inspecting or for conducting investigation. Hope that is clear. Next, section number 218, protection of employees during investigation. Now, it might be possible that once government has ordered investigation onto the company might remove some of the employees. Okay, there might be possibility that employees, let's say an employee has given complaint to the SFIO on the company, stating that some not SFIO, to central government on the company, stating that certain fraudulent activities are being taking place. So central government ordered investigation. Now here in this situation, investigation has been ordered onto the company because of complaint made by this employee, right? So what the company can do, company might remove this employee, company might suspend this employee. So to protect the employee, section number 218 comes into picture. See, during investigation, if company proposes to discharge or suspend any employee or punish him by dismissal, removal, reduction in rank, that is demotion, or change terms of employment to the disadvantage of the employee, okay, to do any of these things which are against the employee, company must obtain approval of tribunal. Okay, only after taking approval of tribunal, company can remove the employee or demote the employee or change the terms of the employment agreement without which are disadvantageous to the employee. Okay, during the investigation period. Now you have company wanted to remove a particular employee. For this, it has to take approval from the tribunal. So it has made application to the tribunal asking for approval. If tribunal approves, see, if employee not satisfied with order, file appeal to the appellate tribunal within 30 days. Okay, company wants to remove an employee, so it has asked for permission by tribunal. Tribunal has given a permission. If the employee who is being removed is not satisfied with the permission that the tribunal has given, in such situation, employee can file an appeal to the appellate tribunal within 30 days. Okay, now if tribunal rejects the application that has been filed by the company to remove a person, in such situation, company also can file an appeal to the appellate tribunal within 30 days. Okay, company is also having option to file the application to appellate tribunal. Next, if no response is given by the tribunal within 30 days, then it will be deemed that tribunal has approved. Okay, deemed approval for removal of employee. Now, here in these two cases, you have filed appeal now. The order given by appellate tribunal will be final. There is no further appeal after appellate tribunal. So, decision of appellate tribunal will be final. Hope that is clear. Next, powers of inspector. See, inspector is having power to investigate into affairs related to the company under section 219. Section 220, power to seize the documents. Section 217, miscellaneous powers and procedure. Okay, this section number 217 we have not discussed. In this section 217, there is some list of powers you can go through. These two we have discussed, right? Sorry, we are going to discuss. Section number 219, investigation into affairs of related companies. Now, inspector is there now. He has been appointed by central government to conduct investigation of A Limited. So he is conducting investigation of A Limited, and there is a subsidiary of A Limited which is B Limited. Okay, now inspector, he is conducting investigation of A Limited. During investigation of A Limited, inspector found out that there are certain transactions that A Limited entered into with B Limited which are fraudulent. So inspector wanted to conduct investigation into B Limited also, that is related company. Whether it is possible, the answer is yes. Inspector is having this power to conduct investigation into related companies as per section 219. See, Inspector appointed under section 210, 212, 213 considers necessary to investigate into affairs of any body corporate which is or was a subsidiary of holding company, or is or was managed by person as managing director manager who is or was also managing director. Okay, that means A Limited is there now. Inspector has been appointed to conduct investigation of A Limited. In A Limited, Mr. X is director. Mr. X is also director in Z Limited. Now, if inspector wanted to conduct investigation into Z Limited, he can. After taking prior approval of central government, he can. Okay, that is the second situation. Next, whose board of directors has nominees of company and accustomed to act as per the instructions of company. Okay, the board of directors of our company are accustomed to act as per the instruction of some other company. In such a situation also, the inspector is having power to conduct investigation into such other company which is a related company. Okay, after taking prior approval of central government. See, for all this, inspector needs to take prior approval of central government. Next, person who is or was managing director, manager, employee of the company. Okay, the inspector, he can also conduct inquiry or the investigation into the managing director, manager, employee of the company. Okay, so in all these related parties, the inspector can enter into. Okay, originally inspector has been appointed to conduct investigation of one company, but during the investigation, if he feels that some other persons also need to be investigated or some other parties should also be investigated, who are those other parties? These four. In such situation, inspector, after taking prior approval of central government, can inspect these people. Hope that is clear. Next, section 223, which deals with inspector's report. Inspector, after conducting the investigation, he will give report to the central government. It will be in writing. Copy can be obtained by members, creditors, person whose interest is affected. Okay, this copy of the inspector's report can be obtained by these people. Now, report authenticated by seal of the company. Seal of the company should be there on the report, or certificate of public officer having custody of the report. Okay, next. Section number 224, actions by central government based on the report. Now, central government has received the report of the investigation that is given by inspector. Based on the report, certain actions can be taken by central government. What are they? Prosecute such person who is found to be guilty. Okay, can initiate prosecution on the criminal. Make petition to tribunal for winding up of the company. Okay, central government can make a petition to the tribunal. This company is there na, in investigation it is proved that this company is doing fraudulent activities, you please wind up this company. Like this, the central government can order the tribunal. Next, wind up means closing off of the company. Next, application to tribunal to order for disgorgement of assets fraudulently used by director, key manager, personnel, employee of the company. Disgorgement means giving back of the assets that has been fraudulently used by director, employee, key manager, personnel. So these orders, these actions can be taken by the tribunal based on the order of the inspector. Okay, yes. Next, section number 226. Investigation proceedings shall not stop even if application is made under 241. Okay, any shareholder, if he makes application under section 241, that is operation application, then also investigation will not stop. Let's say investigation is initiated on the company. During this investigation process, tribunal receives a application under section 241, that is operation application by the shareholder. In such situation, sorry, this investigation will continue. Okay, there will not be any disturbance for the ongoing investigation because of the 241 application. Next, company passed special resolution for voluntary winding up. Okay, during the investigation, while investigation is going on, company has passed a special resolution deciding to wind up the company, even though the investigation will not stop. Investigation must go on. Next, any proceeding related to winding up is pending before the tribunal. Okay, even if any any proceeding related to winding up is pending with the tribunal. In such a situation also, the investigation that has been started will not stop. Okay, whatever the scenario that might take place, the investigation once started will never stop until it is completed. Hope that is clear. So by this we have completed the fourth chapter, which is inspection, inquiry and investigation. Okay, so we'll be meeting in the next class. Until then, take care. Bye bye. See you.